Great. Hello, everyone. This is Tax Chat with the Center for Taxpayer Rights, and I'm Nina Olson, the Executive Director of our Tax Chat. And we are here today to talk about administrative burden and taxpayer rights. And our guests today, other than myself, I'm my own guest, I guess, today, is our professors Les Book and Keith Fogg. And Les is at Villanova Law School, and Keith is at Harvard, leading the Harvard Tax Clinic, Federal Tax Clinic. And so today, the topic for today is, and it's a little self-serving because Keith and Les and I have been working for a while on a paper, an article dealing with administrative burden. And I'm a Johnny-come-lately on the paper, but Les and Keith have been working on it longer. And we thought this was probably a topic that people would want to learn about. And although we're looking at it from the lens of US tax administration, I think administrative burden is a huge issue all over the world with tax agencies. And the paper's not yet public, but we'll post a version of it when we're sort of comfortable with it and put a link to the SSRN page where it's posted when we're ready. But I'm going to start by letting Les start to frame the concept of administrative burden, and then we'll each sort of talk about what we've been thinking about, what we're proposing. And what we're trying to do in this analysis is also incorporate taxpayer rights into this concept of administrative burden. The United States has a Taxpayer Bill of Rights, and one of the key questions is, well, how do you apply it? How do you enforce it? How does it become something that is central to the operation of the tax agency? And that has also become a component of this administrative burden analysis. So what you're doing is going beyond sort of, cost benefit analysis, of just quantifying, paperwork burden and really looking at a rights-based analysis of administrative burden. So Les, do you want to sort of frame and explain how you got into this? And
Sure.
also, just as a point, I'll be watching the chat. If you have questions as we go along, please put them in the chat. We'll also reserve time at the end so you can ask questions as well. Go ahead.
Thanks so much, Nina, and it's a pleasure to be here and talk about this project, which, as Nina mentioned, Keith and I had been working on for a while. We started maybe a little over a year ago, and then we got sidetracked in some other projects and have come back to this. And it's really the topic itself is one which kind of stems from literature outside the legal academy and tax in particular. There's public administration scholars have been thinking about the relationship between government agencies and individuals, and in particular have discussed and framed the various burdens that individuals experience when interacting with government. And there was a book a couple of years ago from Don Moynihan and Pamela Hurd called Administrative Burden Policy Making by Other Means. And they looked at relationship in between voters and voter registration laws, healthcare, traditional welfare programs, and cataloged and discussed the ways in which individuals experience government, and looked at and defined burdens in a more granular way that we found to be really helpful in applying to the tax system. And what they've done basically is define burdens in a way to include three distinct categories of obstacles or frictions: learning costs, compliance costs, and psychological costs. And learning costs are traditionally the kinds of things which individuals have to overcome to find out about, let's say, eligibility criteria. Compliance costs are the costs that are necessary or that are imposed in responding to, let's say, requests to prove eligibility. And psychological costs include things like stigma and anxiety around either trying to learn information or responding to information. And the insights that the public administration literature presents not only include kind of a more granular definition of these kind of frictions, but also a real detailed understanding or discussion about how the burdens can matter a lot. And especially when you take a look at those in the context of distributive issues, and meaning that the way in which we may experience a compliance cost differs greatly than someone who is maybe suffering through some challenging economic circumstances, or is experiencing homelessness. And so the burdens matter a great deal. They matter a great deal more to certain individuals, and there's a lot of research around how things like scarcity and poverty has a direct impact on not only ability to, but willingness to engage with and respond to requests for information. And a final insight from the literature is that sometimes the burdens are inadvertent and sometimes are intentionally imposed. And so in the kind of the discussion in the literature talks about how at times burdens are interjected as a way to essentially frustrate other public policy goals that are otherwise expressed in a statute. And so, for example, if there are robust voter protection laws on the books, but there are obstacles that a local administrator might put in the way, in terms of not allowing certain people to come visit a line and deliver food or deliver water, or obstacles that that are essentially outside the statutory requirements but are superimposed in a way that can frustrate and counteract kind of other policy goals. The other kind of final insight, and then I'll stop, is that there are justifications at times for burdens. And it doesn't necessarily mean that there's no good reason for an agency to interject requirements or impediments. The most important of which, and the one that has the most significance for a tax system, is a concern around integrity or program error. And a lot of times the challenge is sometimes burdens are inappropriately imposed and justified in the face of what is apparently or ostensibly a fraud concern, but is really just kind of a subterfuge for preventing the achievement of a policy objective. And again, that comes up often in the context of, let's say, voting rights, where you hear a lot about, talk about voter fraud, but actually on the ground, there are really, really limited instances of fraud. So what we've tried to do in this paper is apply this framework to the tax system. And in the US anyway, our tax system is really predicated on personal responsibility and individual responsibility. And from tax return filing to responding to the agency in examinations or correspondence examinations to collection cases, there is a significant, there's significant responsibilities or requirements for individuals when they interact with the IRS. And as we point out in the paper, it doesn't have to be that way, right? There are ways to think about how the government can either shift the burdens to itself or on third parties, and most commonly thought of in the context of return filing. Our return filing system is one where there's significant barriers. The IRS has information such that it could pre-file or prepare returns, templates of returns for upwards of maybe 30-40% of taxpayers, where there would be a fairly significant overlap to what a final return would look like. Yet again, and some countries have that kind of default. So that's the framework, and what we've tried to do, as Nina points out, is really kind of drill down to the tax system and then connect this to taxpayer rights. Because the challenge is trying to come up with a framework that not only identifies burdens, but frames burdens as when are they excessive and when are they inappropriate, and that's kind of that's where the project goes, and where I think we're adding value and contributing is trying to come up with giving a template for thinking about when burdens are excessive, and how the IRS and Congress at times can take affirmative actions to reduce or shift those burdens.
So, Les, you've used that word excessive burdens, and before, I turn it over to Keith to talk about what things exist in the IRS system or the United States system to try to measure burdens as they exist. Maybe you can talk a little bit about, what is defined as an excessive burden, but also, where that fits into the more traditional cost benefit analysis and how you get from, into the sludge analysis.
Yeah. So what we've tried to do in thinking about this is again, that where the rubber hits the road is thinking about when a burden is excessive. There's a long tradition in the U.S. system, and which has been kind of accelerated and emphasized in the last 15 years around thinking about things from a cost benefit perspective, trying to analyze kind of a quantitative welfarist approach. But what we've tried to do is suggest that that a proper way to think about this, a helpful way to think about this is not only from a pure cost benefit perspective, which is important, but also to think about whether and to what extent a burden is excessive. And by that, we mean looking more carefully at the distributive effect and whether the burden falls upon kind of a discrete class or group of taxpayers. And we've tried to drill down deeper and kind of identify when burdens have fall disproportionately on either low income or underrepresented taxpayers. And secondly, when the burdens have a material impact on fundamental taxpayer rights. So we look at low income, and we refer to low income generally as consistent with the definition in the Internal Revenue Code that defines low income for purposes of low income taxpayer clinic representation, which is at 250% of federal poverty guidelines, as well as underrepresented taxpayers, including taxpayers where there may be a disproportionate cost of trying to navigate, of hiring representation relative to the amount of tax or in dispute. So you can have, someone being viewed as underrepresented if they're unable to navigate the dealing with the IRS on their own, and the costs of professional representation are disproportionate to the tax at issue. And also in looking at burdens that fall disproportionately on marginalized communities. And so, and a challenge with that latter aspect is the IRS has traditionally not really collected or disseminated information on kind of the racial impact of tax administration, and that has been, and that is a topic which has gotten a lot of attention in the last couple of years. So that is a challenge. What are the racial implications of some of these burdens? But we suggest that an agency that is mindful of or aware of these burdens and aware of how it impacts certain classes of taxpayers and how it impacts taxpayer rights can kind of take the next step, which, as Nina points out, is reducing those burdens. And there's a term that Cass Sunstein refers to as sludge, which is what he refers to as when burdens are excessive. And so for us, the sludge exists when the burdens fall disproportionately on underrepresented or low-income taxpayers, and when they have a material impact on fundamental taxpayer rights.
I also think that material impact on fundamental taxpayer rights then takes it out of just looking at low-income taxpayers and things, so that a burden analysis, an excessive burden analysis can apply to all sorts of groups. And one example that we've sort of discussed in one of the footnotes is for example, U.S. taxpayers overseas. The United States taxes its citizens on their worldwide income, and it taxes U.S. residents on their worldwide income, residency being defined in the Internal Revenue Code and not necessarily based on your immigration status. And yet, if you're a taxpayer overseas and you're trying to get in touch with the IRS doesn't allow email. You can't email them. There is no toll-free phone number for an overseas person. And so that grossly violates the right to be informed. It violates the right to quality service. It involves the right to all sorts of, in our taxpayer Bill of Rights, your ability to communicate with the IRS, challenge the IRS's position and be heard, your right to a fair and just tax system because you can't communicate. So although that might not be your traditional category that you're thinking about, if the IRS is proposing some kind of initiative that's going to impact that population, it needs to do some kind of an analysis to see whether it's imposing excessive burden on these taxpayers or in some way impeding their exercise of their taxpayer rights. and then mitigate that approach, come up with approaches that would address those excessive burdens. So Keith, why don't you talk a little bit about some of the systems and laws that operate both inside, government-wide, federal government-wide, and then some that, apply to the IRS that we looked at as possible models to learn from in developing some kind of a rights-based administrative burden framework.
Thank you, Nina. Yeah, the first sort of, mostly I'm going to talk about burdens, systems that have been designed by Congress that are government-wide, not specific to the IRS, because there really hasn't been any legislation specific to the IRS to reduce burdens, and that's sort of what we're looking to see might happen. But the first one I'm going to talk about is the Regulatory Flexibility Act, which was enacted by Congress to protect small businesses. So the idea of this legislation is that when an administrative agency is in the process of rulemaking, they must specifically address how the rule that they are making or the regulation impacts small businesses. And small business is a pretty broad group, but they're in making the regulation, they're supposed to make comments on how this regulation will affect that group. The IRS has, at least according to GAO, done a particularly bad job of doing that. It kind of just slaps something onto a lot of regulations saying this doesn't affect small businesses, and then hurries along to the next point. So they have, the IRS at least, and some other agencies have been criticized, but it can be difficult. But you see why Congress would be interested in this, because there could be legislation that wouldn't be hard for a large corporation to absorb the cost of meeting whatever regulation follows on, but could be crushing for a small business to try to meet that regulation. And then going kind of to Nina's example of overseas taxpayers, there's recent litigation in the DC District Court in a case by the name of Silver versus United States, where a U.S. citizen who has a law office in Israel brought a suit under the Regulatory Flexibility Act because he said it was the regulation interpreting a change in the law in 2017 was very burdensome to him, and he spent hours and hours trying to comply with the regulation, even though he had no tax cost. He had to jump through a bunch of hoops, but there was no tax consequence to his business. But yet he still had to spend hours and hours to comply. His case, just in the last few weeks, was dismissed for lack of standing. But it highlights the difficulties that a regulation can create. And here it was a tax regulation, but it could have been any kind of regulation. And that's what the Regulatory Flexibility Act was passed by Congress to monitor the burden that's being imposed on small businesses. Another nationwide or agency-wide burden reduction that came into existence over 4 years ago is the Paperwork Reduction Act. So this is an effort by Congress to force the agencies to think about, what burden are they imposing upon individuals and businesses as they create requirements that require those individuals and businesses to fill out forms and paper. And of course, with this one, the Internal Revenue Service is really the largest agency that it impacts. And the IRS, unlike the criticism that they received for GAO for kind of slapdashing the Regulatory Flexibility Act, the IRS pays a lot of attention to the Paperwork Reduction Act because it's creating more burden than any other agency in the United States. So Congress is forcing them to go through OMB or IRA within that to get approvals for certain forms as they come out with new forms and new impositions of paperwork on taxpayers. The IRS has developed a lot of systems to comply with the Paperwork Reduction Act, but that doesn't, just because there's such a thing as the Paperwork Reduction Act doesn't actually mean that paperwork is reduced. It simply means that we're monitoring the paperwork that's being required of us and in an effort to look at whether it should be reduced. So another burden system out there, but not, again, not specific to the IRS, but yet one that heavily impacts the IRS because the IRS is requiring people to produce so much paper. A third one that's across the board and a little bit unique with the IRS is the Privacy Act. Here the idea is not as much to seek reduction of burden as to seek reduction of intrusion at the individual level and at the systems level. It deals with both information gathering and information maintenance. A lot of the Privacy Act issues that might otherwise affect an agency like the IRS are taken over by the disclosure provisions of the Internal Revenue Code that have certain requirements that would be even higher than the Privacy Act provisions. So there's an overlay there and some specificity because of taxes, but it's another area where Congress is looking to see what burdens there are. An Internal Revenue Code provision that reduces burden, specifically in one instance, that was driven by a court case that went to the Fifth Circuit, is the Section 6201D, which flips the burden of proof on taxpayers and therefore from being on taxpayers to being on the IRS when there is a 1099 issued, an information return issued, and the government receives that third-party tax return, that information return, and the taxpayer didn't report it, and the IRS says, where's the money, where's the tax on this income that you earned that's reported to us on the 1099? And if the taxpayer says during audit, that's not me, I don't know anything about that 1099, then the burden of proof shifts to the government to force the government to come forward with the information. And that is an appropriate shift of burden because otherwise you have the taxpayer trying to prove a negative. So that's one example of a specific burden reduction in the Internal Revenue Code related to individuals. But there's no broad-based burden reduction in the Internal Revenue Code. So that what we are trying to develop is something that would affect taxpayers in a broad-based way to try to reduce their burden through certain analysis.
So there's an office in the IRS called the Office of Burden Reduction. You want to talk about that for a sec?
Yeah, not a whole lot to talk about in the Office of Burden Reduction. It's a very small office that I've never encountered myself, but designed basically to comply with the Paperwork Reduction Act. So most outsiders, and even I was an insider for 30 years, I never saw this office. So it's kind of niche, but it's monitoring the compliance with basically the compliance with the Paperwork Reduction Act. It's not really seeking to reduce the burden of any particular taxpayer. It's really seeking to make sure the IRS complies with the Paperwork Reduction Act. So
yeah,
I would say the name's a little bit of a misnomer.
And the focus seems to be, what the IRS has tended to marshal its resources on is looking at time spent on completing filing, forms associated with the filing process,
right,
which is not insignificant, and as Keith points out, is a real significant source of costs. But we're trying to broaden the lens and beyond that, and so the IRS's focal point has just been different.
Right. And the other thing, I mean, having been inside the IRS, and having to interact with the taxpayer burden reduction and also with the privacy office there and actually having to complete privacy impact statements, which I'll chat about in a minute. One of the things, the burden reduction office has a model that has been developed, and one of the things that they consider additional burden, which goes to the Paperwork Reduction Act, is how many lines are in a form. And, you know, we always had these conversations with them like, well, this particular line, it may add another line to the form, but it actually helps explain the steps to the taxpayer and is actually helpful to the taxpayer. But you're going up against a counting mechanism that equates into burden under their formula rather than a more rational thought process and a more flexible approach. So we've looked at all of these approaches in the US federal government and even some of the things inside the IRS to try to think about how would you incorporate into the IRS as they're developing initiatives or as initiatives are ongoing, the actual, you know, and burden analysis or rights-based burden analysis. And I thought that we could use something like the environmental impact statement that agencies are required to do when there are, you know, mining proposals, any sorts of proposals. There has to be an environmental impact statement. And at the same time as that statement was coming about in the 1970s is when the Privacy Act came in. And part of the Privacy Act was the Privacy Impact Statement, which requires all federal agencies, when they're doing a collection of data, to go through this analysis, both of how they're going, you know, what is their need for data, who is going to use that data, where are they going to get it from, and how is it going to be applied? What privacy rights are triggered with that data, and the issue, the privacy issues, and then their implications. And then you put all that in a privacy impact assessment report that is then required to be posted by the agency online publicly, so that people, if you're going out to gather information, even if you're doing a survey of taxpayers, you have to go through this do a privacy impact statement assessment. And that is posted, and you can go onto the IRS and look at some of their privacy impact statements. They're not particularly informative. They're very, they don't really give you a lot. They're very done like rote, which is some of the GAO, the Government Accountability Office, criticisms of the IRS's you know, conformity with the Regulatory Flexibility Act affecting small business. If they do that analysis, it's very cursory and high level. And most times they're saying, oh, this doesn't affect them at all. Don't worry about it. So we were, you know, taking that experience, you know, we're thinking, well, what are the strengths of these pieces and how can we drive it in such a way that you actually get a meaningful assessment of burden? And that's sort of where, you know, we came up with this thing that I had actually proposed as the National Taxpayer Advocate several years ago and issued a few during my tenure, but we never really codified it, and it seemed like a useful tool. We never really incorporated it, formalized it, which was a taxpayer rights impact statement. And again, that was built on the privacy impact statement and the environmental impact statement, the concept behind it. And so what we really wanted to do was, first of all, shift the burden analysis to focusing on what the taxpayer was experiencing. And that means that you're looking at, like Moynihan and Hurd suggested, you know, not just the compliance costs of, you know, how many hours you spend filing, but both the upstream and the downstream consequences of filing. So how difficult is it for you to get information in order for you to be able to file? And that goes to your learning costs and also your anxiety, your psychological costs. And then downstream from the filing is, you know, you obtaining, you know, you're being audited, you're being collected against, you have an appeal right, you have a right to challenge it in courts. What are the burdens associated with those things, both in fulfilling, you know, the requests from the IRS for providing information, for understanding what the IRS is asking of you. And what we wanted to drive was that the IRS consider these burdens, both upstream, downstream, and within the program itself. So that's where the Taxpayer Rights Impact Statement came in, modeled after the Privacy Act. And we divided it up into a bunch of steps. And some of this came from me having, and also Keith rather, having lived inside the IRS for significant period of time and observing the IRS as a bureaucratic agency. You know, you're always wrestling with, if you give it a checklist, it's going to follow it like a checklist and you're going to get something fairly rote. So how do you do a system that still encourages people to think? And, you know, and not just do things by rote. And I can't say that we've done that, but we've made a stab at it. And so, you know, this taxpayer rights and burden analysis is to first, you know, you would step up and you would, if you're proposing a new initiative, and we could say it's an education initiative, but it could also be an audit initiative. It could be a collection initiative. It could be any kind of initiative whatsoever in the thing. It could be, for example, that you're proposing to move something online and you've been traditionally doing on the phone, giving assistance to taxpayers on the phone or face-to-face through our assistance centers. So to make that change, you need to, first of all, describe what you're proposing to do and what's the policy, the public policy purpose for this initiative. And that also goes to something that Les said earlier about there may be legitimate reasons for imposing this burden. That by describing the proposal and the reason for this proposal, you're identifying why you might need to impose more burden than in other instances. So then you have to do your program flow analysis, is really mapping out. And this is where the thinking has to go in. And where I do think like a checklist or a roadmap kind of approach really helps is making people think through the steps of this process and the steps of how, you know, who is going to have to provide the information, what parts of the population are going to be impacted. That's another step. Like once you've laid out the whole like flow of this program and the information you're going to need, and what steps you're planning to take in this program, you've got that little roadmap. Then you start thinking about who are the impacted populations. And as part of that process, you're going to start identifying what Les has said, is there a disproportionate burden on certain taxpayer segments? And it's not just, you know, the low income taxpayer, but many other possible groups that might be impacted depending on the initiative. And then you go to, once you've identified the impacted taxpayer segments, particularly those that are disproportionately impacted, that's where you do your analysis of the taxpayer segment. And you look at the characteristics of that segment to say, you know, do they have literacy issues? Do they have digital skills? Do they have access to representation, or will that be a bar in their, you know, obtaining their rights if you're doing an audit initiative? What are the characteristics of that population that would create the risk of excessive burden, either learning, psychological, or compliance costs? And then the final aspect of that then becomes that you would do this taxpayer rights burden analysis. You've now identified what the flow is, what things you're expecting, what data you're expecting, what actions you're expecting from taxpayers. You've identified the taxpayer population and you've analyzed the taxpayer population. And then you layer on that, you know, your taxpayer rights analysis. And in the United States, we have the Taxpayer Bill of Rights. We also have all sorts of statutory rights that are protected. And the Taxpayer Bill of Rights is statutory as well. It's in the Internal Revenue Code. But you would do that analysis to think whether this burden, whether this proposal, this initiative as proposed, is going with in view of the population that is impacted, the taxpayer segment that is impacted, and their specific characteristics. Will there be, you know, an excessive administrative burden such that fundamental rights are undermined, and their ability to, the taxpayer segment's ability to navigate this segment is significantly burdened? And once you've done all that, you sum it all up as a taxpayer rights impact statement. And so the idea about that was that you would be using a questionnaire of a sort, which was similar to the privacy impact assessment questionnaire in the IRS, but you would do a questionnaire that the program owner itself, whoever's proposing this initiative, would have the responsibility for going through the analysis, which right there makes the IRS entities have to think more than they are currently thinking about the taxpayer populations that they're impacting. So right there, you're trying to drive some culture change and some behavioral change in the agency, that the program owner itself can't put it off on somebody else, that they're responsible for thinking through these things. And once they've filled in this questionnaire, basically the first 5 steps that I've outlined, that questionnaire, and the program owner is to identify, if you've identified burden, then you propose mitigations of that burden, or you make the justification that this burden is justified because we have to, protect the program integrity. Okay, fine. That then is circulated through the organization, the IRS. So it would go to the Office of the Taxpayer Advocate. It would go to the Office of Chief Counsel. If you're proposing an audit initiative, it would go to the upstream functions. So the people on the phones who might get questions, calls in, or there might be a disproportionate amount of mail that would come in. It would go downstream to the appeals folks. It would go to the Office of Chief Counsel to look at possible litigation issues that might come up. And people then, if you got upstream and downstream, plus a taxpayer rights review from the Taxpayer Advocate Service, you've got a 360 looking at this proposal, which is not unlike what happens with the Internal Revenue Manual, which are the internal instructions for the IRS staff, that when a function in the IRS is proposing to change its procedures in some way, it has to circulate those procedures throughout the agency. And for certain sections of the IRM, you're identifying what parts of the agency need to see these changes in procedures. And so we're sort of piggybacking on that process, which the IRS is already comfortable with, but we're doing it for this taxpayer rights impact statement. So you get a 360 view of these concerns. And then, there's negotiation about whether people have objections to some of the things that the function is proposing. And so the ultimate taxpayer rights impact statement will reflect the objections and how those objections were addressed. And then that taxpayer rights impact statement is shared with the leadership that has to make a decision about whether they're going to go forward with this initiative or not. But you've got it basically surfaced and transparent. And finally, the taxpayer rights impact statement is made public. Just like with the privacy impact statements, they would be posted on a dedicated web page for irs.gov so that taxpayers and their representatives and advocates and stakeholders could see what's in there. Now, one other thing that we've proposed is, okay, we've said that the function itself has to fill this thing out and has to do the analysis. It's going to have to rely on a lot of people to get it data and things like that. But the point is, it's responsible for doing this. But we really thought a lot about, well, who sort of governs the process? And that's where, I encouraged our thinking the process itself should reside in the taxpayer advocate's office. That setting out how the process works really would, if you put it with the taxpayer advocate, who has a special mission to make sure that taxpayer rights are protected and is the voice of the taxpayer inside the IRS, then if the process is being treated in a offhanded manner and the functions are not giving it the respect and the attention that it needs, the taxpayer advocate can twiddle with the process and make it more robust, or can report on the IRS's failure to really do the process correctly and the analysis in a robust way in her annual reports to Congress, and raise that as an issue as well. And so we thought that was maybe inappropriate, rather than putting all, like, the taxpayer advocate doing the analysis herself. putting the responsibility of the analysis on the agency because you're trying to drive systemic change and cultural change, but you have the oversight function and the design of the process in the hands of the Office of Taxpayer Advocate. We had a lot of other things to say about, like the process downstream, but I thought I'm going to give Les and Keith a chance to chime in, and we do have a comment. David Massey said, we are supposed to have regulatory impact assessments in the UK, but they do feel to be the box ticking exercise you warn against. I think you probably need to audit some of the older ones to see how thorough, reliable they were. Well, that's really interesting because, one of the things that we talked about was how to make sure that they become meaningful. And we also talked about, this is for new programs. And then we were talking about, well, what do you do for existing programs? And again, that's one of the reasons why we wanted to put in the Taxpayer Advocate, because the Taxpayer Advocate has those 2 reports to Congress that get delivered to Congress directly without any IRS review, or it used to be without any IRS review. That's changed a little under the most recent Taxpayer Advocate. But one thing we thought was for the existing programs, in the June report to Congress, every year, the Taxpayer Advocate could pick 5 existing programs that maybe they'd written about as being really problematic for taxpayers and creating burdens for taxpayers, and say in the June report to Congress, we have identified these as having great risk of administrative burden, excessive administrative burden, and therefore we will be working with the IRS to conduct a taxpayer rights impact review of these 5 programs over the next year, and we will publish our responses to them in the next year's June report to Congress. So the IRS has time to go through that and process. And if they do box ticking, then it's set up that the National Taxpayer Advocate can then point that out and say the IRS didn't do a legitimate review, did box ticking. Here are our concerns, and if you really did it right, here's what it would look like, and here are the mitigations that should be done. And so you're really getting public that kind of review. And maybe Keith, you might want to talk about, the role of TIGDA and GAO, the Government Accountability Office, and the Treasury Inspector General for Tax Administration.
Yeah, I think that the problem that David identified is a very real problem, and just creating this system won't necessarily change the culture at the IRS, although that's certainly the hope, that it would put a focus on taxpayer rights that would work toward changing the culture. But there are oversight bodies of the IRS, and I'm going to talk first about TIGDA. But if you go back to 1998, Congress put a lot of responsibility on TIGDA to review specific actions of the IRS that were troubling Congress in 1998, and in which they made a lot of changes to the law in 1998. And still today, in 2021, TIGDA is required to do an annual report on about 15 or 20 specific aspects of the law. Like they have to look at every seizure the IRS does in a tax year and analyze. And so every year you get a report from TIGDA, whether there's been any seizure problems or not, looking at every seizure the IRS has done. And so it would be, and TIGDA has their own sort of government accounting way of looking at actions of the IRS. And so their reports are pretty stylized. In some ways, in some reports, very helpful for getting data that you can't otherwise get about what's happening at the IRS. So I don't disparage TIGDA reports, but if Congress or if TIGDA adopted, reviewing the taxpayer rights report, then they would produce a report in which they would agree with or find problems with whatever the IRS was doing in its burden reduction analysis, and that report would go not only to the heads of the IRS and theoretically get commented upon by the commissioner, so it would get into very high levels of the IRS. It would also potentially get into Congress, and so TIGDA in its audit function could play a very a very powerful role here in seeing that there was compliance with taxpayer rights. GAO has a, I would call it a broader writ than TIGTA, and less annually required. But they are regularly looking at what the IRS does and doesn't do, and coming out with reports that are I think individually are more powerful than the reports from TIGTA, and they're specifically going to Congress. So GAO is another oversight body that can look at what the IRS is doing or not doing in complying with taxpayer rights, and make comments that could lead to legislative changes, if not changes inside of the agency. So there's oversight bodies present that could come to bear if a taxpayer rights analysis adopted, and that would be, I think, one of the most powerful ways for this to become a meaningful report with oversight that requires those doing it not just to be checking the box.
So before we go, there's some really interesting comments going on, but before we do that, Les, do you want to talk about, because we spent a lot of time thinking about remedies, and this is also part of the problem with the Taxpayer Bill of Rights. How do you enforce it if there is a violation of the right to quality service, right? But you've given some thought to, where of finding that, through this administrative excessive burden might play in under the Administrative Procedure Act, where there is actually a final agency action, and maybe give a little bit of background to the Administrative Procedure Act for our international viewers.
Sure. Yeah. A common question we've gotten when we've talked about this project is, well, what happens if the IRS just checks, ticks the box or doesn't do it in a proper way? And we've been, I do think the information forcing aspect of this is significant in and of itself, and I do believe that will be, if done with good faith, that is going to be important. But as Nina points out, there is this question about whether and to what extent there is a possibility of holding the agency, having an external source of a judicial source of check on what the agency does or doesn't do in this context. And the Administrative Procedure Act could potentially play a role, which is in the context of agency rulemaking, it allows a court to evaluate whether the final agency action, something that is establishing, with finality rights and obligations, is in some ways an abuse of its discretion, and allows a court to examine whether the agency has failed to exercise its discretion appropriately. And if it has not done the job properly, a court can essentially, compel the IRS or an agency to go back and do the job in a manner consistent with what it's required to do. And so there's the possibility of using the Administrative Procedure Act to, if there was an impact statement that was done in connection with something that reached the level of final agency action, one could imagine a litigant, bringing an action in court, essentially asking for the district court to compel the IRS to do a better job, to more, properly evaluate the impact to communities and examine the impact on fundamental taxpayer rights. The APA has increasingly become important in the context of evaluating IRS regulations and rules. And so it's an evolving area of the law. And there are only limited ways in which individuals or taxpayers can bring an action in the using the APA to challenge, and including, principally it has to revolve around an enforcement action, either a deficiency case where the IRS is examining a taxpayer, or a refund case. But there is also the potential in collection cases, so-called collection due process cases, which without going into too deep of a dive, there allows for a court to essentially do its own balancing test to balance the agency's actions, the agency's interest in efficiently collecting taxes, with taxpayer, essentially the taxpayers' rights to ensure that the agency's actions are no more intrusive than necessary. It's almost an inherent kind of rights-based balancing test that is within the collection due process provisions. So one can imagine if there were a collection case that and a taxpayer were alleging that the IRS failed to go through properly do its work under the taxpayer rights impact statement approach, one can imagine a CDP case being a vehicle for a court to compel the IRS to do its job. Now, but those are, I'd say, tangential. I mean, they're not directly connected to our proposal, but I think they're important. Just as Keith describes GAO and TIGTA, I think there is a potential role for the courts to ensure that the IRS is not systemically ignoring what it should be doing.
I had not even thought about making this a legislative proposal. You've just put that in my mind. So let's take a look at what we've got in the chat here. We do have some examples in the paper that we can also discuss, but I want to bring folks in. I think David Massey is here and Robin Williamson. They're really talking about the regulatory impact assessments and also some work under the Equality Act. So David, I don't know whether you want to come on and talk a little bit. I can unmute.
No, that was fascinating. That is giving me loads of things to go back and think about what we should be reviewing in the UK system there. So plenty to keep us busy over the summer there, I think. So thanks very much.
But do you find that your regulatory impact assessments, are they not necessarily helpful, or are they providing any information?
I think it's better than the nothing that was there before. I was just trying to look them up. I've had problems with me reconnection. They are a bit bland, and it's very much in monetary terms. So perhaps if we can get a way of analysing the potential sludge with these things, with that, so that those are considered perhaps a bit more, because at the moment I think they've just sort of got 5 lines where they can sort of say, oh, it may have a burden,
right?
But all the emphasis is putting numbers on things to put in the boxes, as opposed to thinking more deeply, I think, and putting themselves in the shoes of, say, a small business or an individual.
Right. Robin, you had a comment. Do you want to unmute and basically say your comment?
Yes, thank you very much for a wonderfully interesting presentation. My own background is that I used to run the Low Incomes Tax Reform Group here in the UK, which is part of the Chartered Institute of Taxation, looking after the interests of unrepresented low-income taxpayers. And we used to do quite a lot of consultations with HMRC, our tax authority. They used to consult us some of the time about some of their impact assessments, particularly those which they did under the Equality Act 2010, under which protects the interests of disabled people and it aims to prevent things like sex discrimination, race discrimination, and so forth. Where we were consulted on the draft impact assessments on policies, and we were able to comment on them, that did seem to encourage the officials involved to take the impact assessment seriously. But the reason they consulted is because sitting in Whitehall, how could they possibly know what things were like for people who are unrepresented and for whom tax was just not part of their daily life. So that is why they consulted, and it did resist the temptation to do the box ticking. I hope that practice continues now, but from what David was saying, maybe there's still quite a few gaps in those assessments. If I just make a point about the judicial oversight as well, we have here the judicial review system, whereby you can take the revenue to court or any public authority to court if they don't do something properly under the Equality Act, like do a proper impact assessment. And the effect of winning in that arena is that the revenue have to not implement their policy until they've done the impact assessment correctly, or if they've already started implementing the policy, they have to suspend it and do another impact assessment. That is, of course, a very expensive and a rather rarefied process, and it's already under threat from the current government. But it is certainly something that has been done in the past and has occasionally worked here. Thank you very much for giving me airtime.
That's really fascinating. And I've just made a note about, in the stage of the identifying and analysis of impacted populations, you would want the function to consult with outside external stakeholders. So, because you can't know what you don't know, which I think is really interesting. And I think this, the idea, we've got one of our examples that deals with the elderly and disabled populations and how the IRS implemented something in the midst of COVID that was so just blind to the needs of that population, and ultimately litigation was brought, and the IRS and Department of Justice, ceded to the demands, reversed its position before the case could have its initial hearing. So Alice, you had a question. Do you want to ask your question?
Yeah, so first, just let me say, I think this is a fascinating project. And I think that even in the worst case scenario, if it devolves into just a, box ticking exercise, I think that getting the issue of taxpayer burden and the importance of that out there more publicly. So even if people think that the specific idea of the taxpayer rights impact statement is not the answer or is not a good answer, I think just putting that issue in public play is tremendously important. But my question was, during the first part of your talk, you focused on, or you discussed the burden imposed on taxpayers by the obligation to file a return, and the need to start from scratch in filing that return. And so I'm wondering both whether you envisioned this proposal applying only to new initiatives that the IRS started, or whether you also envisioning it applying to what I think is probably the most significant burden that taxpayers face, and that is the need to file a return, and the need to file a return that requires them to make so many determinations. And that, of course, that leads me to wonder, where's responsibility for this and for being aware of taxpayer burdens? Where should that be lodged? Because, ultimately it starts with what Congress legislates that the law requires.
Right. Well, there are two things about that. One is in the 1998 legislation, and this was complexity from both the IRS side and the taxpayer side, Congress charged the IRS to issue an annual complexity report in which it would identify those areas of the law that created complexity for itself and also for the taxpayers. And it issued two reports, one in, I think it was 20 in 2000 and one in 2001. And in 2014, in one of my annual reports to Congress, we focused on the implementation of the 1998 Restructuring and Reform Act to see, well, where are we today? And one of the things I wanted to do was, well, you've got this blank check to write to Congress every year saying this aspect of the law is really difficult for us and for taxpayers. Why aren't you doing that? And their formal answer back was, well, the complexity report is the National Taxpayer Advocates report to Congress. And it was like, no, that's my report. You've got your own report. This is what you need to write. And I thought that was so interesting that when they had an opportunity They just didn't use it, even though it was in the law and required. That's why we decided that housing the process, owning the program, should be in the taxpayer advocate, because the taxpayer advocate has that biannual tool to make public certain things. And at the same time, we thought about the existing programs, that the taxpayer advocate may be more willing to undertake something as comprehensive as what you're proposing, that the biggest burden is in the filing process itself, how we're requiring people to file. The IRS may not be willing to do that for political reasons. It's the commissioner's part under the Secretary of the Treasury. The Secretary of the Treasury may not want to even address that. The taxpayer advocate is theoretically protected from that, and so could say, we think for the next year, we're going to identify in our June report that the IRS should look at the burden of our current filing process. We're not going to identify any other thing. That's the first thing out of the first existing program out of the stable, and look at it. And we're going to report on whether they did a good job of it. It will also be public, but we're also going to then critique how the IRS did. And I think that's one way to get to some of these large systemic things that have existed for a really long time, rather than saying to the IRS, tomorrow you have to start analyzing every single system that you've got. You've got to do it in some structured way. And so that's where we were thinking about that structured way. I don't know, Les and Keith, you weigh in.
And the return filing issue is a really challenging one to consider. And we'd initially, our paper kind of starts off with 3 scenarios where we then, and then we come back at the end and kind of apply our framework to the scenarios. We initially started with the free file and filing as one of the scenarios. And it's actually, we decided to not, at the end of the day, I think we're not at the end of the day, but where we are now, we jettisoned free file as one of our scenarios to discuss, in part because that also interjects the private sector and the relationship between the private sector, taxpayers, and the government, and how kind of burdens fit in. It is actually it's more nuanced and more challenging, in part because the private sector, when it comes to free file, for example, has interjected intentional burdens to try to steer people away from actually using kind of the free file, program that it has, that was set up so that you have, in many instances, you have the private sector, when it kind of is engaged, it may kind of try to steer consumers towards things which are less in their advantage, to take advantage. There's a great book from about 10 years ago called Fishing for Fools, which talks about how the private sector and the market is many times designed to try to ensure that people maybe pay for things which are not in their interest to pay for. And so the filing process itself, the presence of the private sector complicates, as well as private debt collection, which the relationship between the private sector and the tax system and tax administration is really interesting, and maybe the subject of kind of a follow-up, but that again kind of complicates the presence of burdens and how taxpayers experience the tax system.
Anybody else?
Alice, I think the filing system is something that if this process that we're trying to create worked, it could apply to that filing system, but maybe that wouldn't be the first thing out of the box, and that could be another reason we sort of backed away from using free file as an example. That's just such a complex example. It might be easier to build this the system of looking at burden through smaller steps before taking on the big one of filing, but certainly the filing process is something that's very burdensome, and that would benefit from an analysis of how to make it less burdensome. But there, I think there's also a lot of politics in that, not just the free file politics, but the whole return preparation industry politics that would make taking that on just through a taxpayer burden process, a difficult thing for this thing that we're designing to carry the day, I think.
You know, that the politics would be less of an issue in the office of the taxpayer advocate if you're doing your job, because I mean, I ticked off everybody regularly. So, but you do it with work, you know, you do it with good work and accurate work, and you focus on the right, you know, you focus on the issues that, that, you know, anybody reading it would say, whoa, this is burdensome. So you don't need to take on the whole filing process. Maybe you take on an aspect of it and you say, why are we doing it this way? And you chip away at something as large as that. And it's actually really interesting to look at, you know, the privacy impact statements for aspects of the filing process, because you really get very little information and analysis from them, which shows you what happens when it is just a checkbox. And we have Dylan saying, so Dylan, do you want to speak up?
Sure. I mean, I was just gonna, hi, everyone. Thank you so much for this. This is great. Yeah, I've just been, and Les and I have actually talked, and I'm kind of working through something in my own work about administrative burdens and the earned income tax credit. But I've just been thinking a lot very critically about how the tax system is so much different from a lot of other government programs that a lot of the literature is focused on, because primarily it's the government is administering and having folks go through a process, whereas I think majority of Americans are having some form of third party do their taxes, right? And so there's this additional layer that can introduce, as you were saying, less of burdens, but also just knowledge that not only the taxpayer, but also their preparer needs to have. And so from my own experience of just, you know, folks that are both, folks who are in it in both the for-profit and nonprofit, of sort of not having full knowledge of all the various tax laws. So yeah, so I don't know, like I'm just really interested in the paper and kind of seeing as it goes, but that's another thing that I've been thinking a lot as well, and how we interact with multiple systems when it comes to the tax system. So,
you know, one of the things about that's coming up, and I think again distinguishes the US system a little bit from many other tax systems, is how much we run social benefits through the code. And the doing an analysis of, this would be another way to get into the filing system and also the audit, you know, looking at a program like the child tax credit, which we're doing an experiment of it being an advanced payment, is what is the burden on these taxpayers to get the right answer about where their child exists. And then if, as you, both for the filing status with return preparers, if you're using return preparers, and then going downstream from that, if the IRS flags your return, and looking at that process in light of the specific characteristics of the population that you're trying to benefit from this. And one of the examples that we did analyze in the paper was the IRS's implementation of the first round of economic impact payments for COVID, that on April 20th, the IRS, what they had first agreed to do was they were going to say, for persons who had income below the filing threshold of the return filing, because as you know, Les and Keith have both noted, we require people to file returns. We don't pre-populate them. Or you had no filing requirement whatsoever, but you wanted to get this economic impact payment. You needed to file a return. Well, this is in the middle of COVID where there's no support system. It's just in the beginning, March and April. There are no support systems whatsoever. There's no return preparation going on. And people can't go out. for the Social Security recipients, the elderly and the disabled recipients of Social Security to have to file, who don't have any return filing requirement and have to file a return, was an enormous burden. And Congress had actually in the legislation tried to avoid that, and IRS sort of for a while ignored that, and people started screaming saying you can't make them file a return. So what they worked out was that they were going to pay them automatically based on Social Security information. They were going to send out these economic impact payments, or EIPs is what we called them, automatically to Social Security recipients who did not have a tax return on file. But on April 20th, the IRS, and that was good, but on April 20th, the IRS came out and said, people, if you are a Social Security recipient and you don't have a return on file and you want to get money for your dependent, because there was a payment for dependent children as well, you have to come in by midday, April 22nd, to this online portal and fill in your children's information. And that was $500 per child. And if you don't fill it in by that time, you're going to have to wait until 2021 to file your 2020 income tax return to get that $500. Well, that was less than 40 hours for the elderly and the disabled, who, if you did an analysis of their characteristics, they're less likely to be able to navigate an online portal. Many of them may not have broadband access in their home. They're already in a population that's getting a lot of support, but all of their support centers are closed down. Their social workers cannot access them. And so they were not able to enter their information. And that resulted in fact, litigation. The clinic at Les's law school was part of that litigation. And I mentioned before, it came right up to the day in September before, actually it was earlier than that, before there was a hearing by the judge, who seemed very eager to hear this issue, that the IRS changed its position and said it would open the portal again for people who were disabled and elderly so that they could enter their children's payments without having to wait until 2021. And so we took that scenario and just said, if you had done even a cursory administrative burden analysis along the steps that we're talking about, you would never have arrived at that. You might have said, we want you to enter this by April 22nd because we want to get these payments out quickly. That's fine. But then you would have said, but probably based on the characteristic of this population, not everybody's going to get the message because it was sent out by email. We're in the midst of a pandemic, so there's no support systems to get this information out. So let's keep the portal open. And on a monthly basis, we'll do a run again to see if any new dependents have been entered and we can send out supplemental payments. And that was just precisely not the analysis that was done. And of course, what happens is that the IRS then is engaged in incredible litigation that got so much press, and the IRS looked like Scrooge, and cruel in the midst of a pandemic to have this answer, this rote answer, wait until 2021, well, you may not be alive in 2021. So it was just, a really good example of how just even a rudimentary administrative burden taxpayer rights analysis might have driven a different policy decision.
Yeah, I mean, and I think that really is a good kind of summation of it. And it wasn't as if the IRS wasn't. I mean, I think it was well intentioned, right? The argument that it made was, it's doing this because it wanted to get the money out as quickly as possible. And the IRS did an incredible job generally in horrendous circumstances in allowing for the delivery of arranging for it and actually delivering payments in a really difficult time. But again, it wasn't as if, and I think might have been David who made this point about the idea of reaching out to others and getting input and information to ensure that they're really understanding the characteristics of the people they're interacting with. That information forcing and information gathering aspect of our proposal, we think is in and of itself just so important. It's easy to get blinded or sidetracked, when you're not taking in the fuller picture. And I think, you know, in my view, even absent the remedy, as Alice pointed out in her comment, I think this getting this more central and is hopefully what will could have an impact in a way that, you know, I think is, you know, it's just not at the front in every situation, especially when and the COVID example is perfect because there's a lot going on. There's a lot of pressure. Having this, you know, an appropriate checklist or an appropriate approach can really ensure that you don't get written up on the front page of the Washington Post and sued in district court, let alone, you know, take care of and really deliver benefits to the most vulnerable.
Well, and Alice asks, you know, administrative burden also comes from Treasury through the promulgation of regulations, which is an administrative function. Would proposed regs need to have a taxpayer rights impact statement as well? Treasury could do a lot to remove burdens through regulations. And I think that, you know, I mean, we're not proposing this. We're actually, there's a part of it, and I'll let Les and Keith talk about this, where we've been trying to think about this as government wide, but we just happen to know IRS, you know, and tax. But I think that there's a place for that. I mean, Les, do you want to respond to that, or Keith?
I like Alice's comment. We really hadn't thought about making it a part of the regulations as they're supposed to do with the Regulatory Flexibility Act. But that's a good way to interject it into the thinking of every pronunciation that comes out. So.
And you know, the other thing about doing it, if you follow the Regulatory Flexibility Act with the regulations, the other thing is that there's an office in the Small Business Administration, the Office of the General Counsel for Small Business Advocacy, who actually has the legislative authority to file amicus briefs in courts where individuals are challenging a regulation under the Regulatory Flexibility Act. And so if we built this in, you know, I had been asking for amicus brief authority as the National Taxpayer Advocate for years. And that's another reason why you might, you know, that might be a way to give that if you made this part of the regulatory framework, that then you would give the taxpayer advocate the ability to file an amicus brief in any litigation where somebody's challenging the regulation on the basis of excessive administrative burden.
Yeah, and I had actually in a paper, and I think actually at symposium at Temple, Alice, I had talked about, you know, one approach in trying to kind of pigeonhole this in a more of a administrative law framework. I had suggested that the IRS in both regulatory guidance and sub-regulatory guidance have a more formal approach to thinking about the impact of rules on taxpayer rights, and include and have as a requirement include a discussion of the impact on taxpayer rights of the proposed guidance. And that would more closely kind of tether, if that were a legislative requirement, that would greatly facilitate the chance of using the APA to challenge either regulations or sub-regulatory guidance that fail to adequately do that. You know, this paper, I think is much broader because it isn't limited to something that would traditionally be final agency action under the APA. So I think your comment and this idea, they're complementary and they're both getting at kind of highlighting and emphasizing taxpayer rights in different contexts.
Kathleen Allen has a comment about another area. And then we can go back to Alice, and then maybe we'll just have some closing comments. Kathleen, you want to wait? And then Louisa has something to say.
Yes, thank you so much. I was in a low income tax clinic in Michigan, and now I'm working in a different capacity, but I'm seeing as kind of like for the taxpayer, new issues that are be associating now with the SARA. As you mentioned before, Nina, with regard to the stimulus check, we are finding now that these taxpayers are going to be receiving the SARA benefits, and some individuals, and this is for payment of rent, for back rent, and some of it's like $10,000. And some of the HARAs that are dispersing this money are asking the clients to sign a W-9. And And these are things that nobody thought of before they decided to give all this money. So at the end of the year, we're going to have problems because a lot of the elder and disabled individuals are going to be penalized possibly for this money.
So the W-9 is to give us taxpayer identification number, and you're thinking that there might be 1099s issued or, information reporting to the IRS, and that it could possibly result in income tax misrepresented incorrectly, but.
Correct. Yeah.
Yeah.
Yep.
Yeah.
Yeah.
Interesting. Alice, do you want to comment? And then we'll go to Louisa.
Yeah, so so my comment was that I think that there are numbers of areas where Treasury, if it had a mindset to think proactively about simplifying taxpayer burdens, could use its regulatory and interpretive authority to do that. And I'm thinking specifically of what Treasury did back in 1996 when it made the check the box regs final, which completely and dramatically changed the definition of corporation. Something so basic as an entire tax that applies to something defined as a corporation. And they did it by using their regulatory authority. With respect to the problem that you mentioned at the outset of the chat, Nina, the US citizens and residents living abroad, there's recently been a proposal that I find really intriguing. And that proposal is that Treasury could use its interpretive authority to interpret the word individual in Section 1 to encompass only individual human beings that are physically present in the United States for some length of time. If they can define corporation, why can't they define individual? And I think that a change of mindset to do what you folks are suggesting in your paper, to consider taxpayer burdens, could have significant impact on what Treasury uses its regulatory authority for.
Great. Okay, Louisa.
Well, first of all, congratulations for the project. It looks amazing. I'm so looking forward to reading the paper. I also had a question, which I don't know if it's like a further development, but I was thinking about outsourcing. So if the tax authority would outsource to third parties, for example, I don't know, tax debt collection or the technological infrastructure, would in that case the taxpayer rights impact statement also be extended to those cases, or no, would it just be limited to the tax authority? Because I think also in the future, with the development of new technologies being used by tax authorities, there might be the need that they cannot build everything in-house, but they will have to outsource that.
I think there are two issues, and I'm sure that others want to chime in. When Les mentioned private debt collection, where we're outsourcing debt collection, that was, I had done several analyses of the impact of that, and that's really where I actually did do what I would have called a taxpayer rights impact statement, but it was not formally designated as that. And I think that was a legislative requirement, but how the IRS implemented it and whose debt it shipped out. We identified that shipping out low-income taxpayer and low-income Social Security recipient debt and disabled recipient debt meant that they would be agreeing to things that they could not afford to pay, and under our laws wouldn't have to pay if the IRS had dealt with the debt. And so ultimately that led to the exclusion of those populations from the pool of people going out. And I can see, even though there might even be a legislative mandate that you outsource something, that you're still having to do the analysis about how you implement it. I think IT, that's the intersection between, for example, the privacy impact statement and the taxpayer rights impact statement, and then also what Keith referred to as the tax system's own confidentiality laws, because there are actually statutory privacy provisions about contractors and access to information. So you've got all those layers there. So that kind of initiative may have to go through several reviews, which might drive everybody crazy, but tough. Les or Keith, you want to have any final words? This is.
I was just going to go back to the comment by Kathleen, but in some ways that's similar to what, I mean, a way to fix that might be what was done through the Taxpayer Advocate's Office with 1099-Cs and student debt collection. When student debt was being removed because of a disputed debt, there was a big push to keep hundreds of thousands of 1099-Cs from going out the door. And eventually the IRS has bought onto that. And that's actually one of the examples that we intend to use as an example where the IRS got it. I think you saw with the unemployment checks, they seem to have gotten it there, but maybe they need to get it on the example that Kathleen is mentioning.
Yeah.
And I'll just come back quickly to Louisa's point, just to kind of wrap up. One of the things I thought about is when there is a private sector involved, and as Nina's pointed out, as she's done when she was NTA, looking at private debt collection, just the idea of the government having a more affirmative role in thinking about how the private sector is interacting with taxpayers, and that if you look at, again, the free file example in the US is a really interesting one. You look at how little oversight the IRS did over the years in it really looking at the relationship between the return preparers and taxpayers. And it seems to me that a proper role for the government and for the IRS in that situation would have been to really take seriously, it not just benefit from the third party kind of providing the technology and allowing taxpayers to file the returns, but really looking at that relationship, and that wasn't done. So the role of burden reduction when the private sector is involved gets more complicated and more difficult, but there is a benefit that the government is receiving, a direct benefit in many cases. So it certainly, I think, would be part of its work.
So we'll just end with thanking you all for helping us think through this paper. We all have homework assignments now, thank you. But it's all been incredibly helpful. And I'll just close with a reminder that there is the 5th International Conference on Taxpayer Rights on May 26th through 28th. And these are the kinds of discussions that we will be having at those panels. It will be all online. We've priced it really reasonably, I think, and I really hope to see you all there. You can register at taxpayer-rights.org. Okay, bye. Thank you all.
Bye, Nina.
Bye-bye.